Hello, everybody. I thought this camera was going to be super close to my face, but that doesn't look so bad. Okay, welcome to today's webinar. Interesting SRC cases and some tips for GRAMA requests. My name is Rebekkah Shaw. I am the Executive Secretary for the State Records Committee. And I've got Renee Wilson here to help me out. I'm a little extra deaf today, so if you'll just bear with me, and we might need questions repeated, but feel free to unmute and ask questions. I prefer a dialogue rather than just me talking to the screen. So if you have any questions, any thoughts, scenarios, feel free to leave a comment or unmute. That's absolutely fine. Okay, so here is what we will cover. First, the deadlines. There are lots of, when it comes to requests and appeals, there are a lot of days you got to remember. How many days before you respond? How many days to appeal? And sometimes it seems like a lot. So we'll go over those. And some GRAMA tips for what to look for when it comes to requests. And some tips, tricks to save you headaches later when you get requests. And interesting SRC cases. Although I might not follow this PowerPoint exactly and actually interject some of these other slides with interesting SRC cases that come to mind, just so you know. Whatever comes to mind, I might be sharing some extra stories. So first, I'm wondering how many GRAMA requests you get, and how maybe overwhelming it is for you. If you get one a month, you don't get many, maybe 2 to 15, 16 to 30, or if you're actually thinking, let's talk about how many requests I get per week rather than per month, maybe you want to go with D. And so we'll just have it open for a little bit. 2 to 15. Huh?
Do you want to tell them where to find it?
Oh, yeah, I need to tell you where to find it. So there's a poll in the comments. You got to click on the little shapes on the bottom right, and you click that, then you can see the poll. $80 to $115 a month. Oh my goodness. Sherry Maxwell, you're Washington County, right? I wonder how many of those are law enforcement related and how many aren't. My guess is most of them are related to law enforcement, right? But I'm guessing. Less than one a month, 4 to 6 a year. Wow. Okay. Seems everybody gets a lot of requests. Most people get a lot of requests. Okay. The next question is what your records management program is like. Is it just you as the record officer trying to do all the things? You're trying to create the record series, manage the records, make sure things get transferred or destroyed when they're supposed to? Is it just you wearing all the hats? That's A. B, maybe you have a couple people that work with you in your office, but it's not much more than that, and you need maybe some buy-in from the CAO, from county council or something, and just some more support, more funding or something would be nice. Everybody could use more funding, right? C, you're part of a team. There is a records management team. You've got policies, procedures, but you still don't have a staff that's quite as engaged as you would like, or maybe you need more buy-in for your chief administrative officer. Maybe they need some training. And then D is the gold standard, I guess. This chief administrative officer is leading the charge. You have a records and information management team that has IT, it's got legal, it's got risk. You've got a lot of subject matter experts. You regularly meet, the staff gets training, and we want to come and see how you do it. So that's kind of what I've got. Oh, we got a lot more C's than I thought. Everybody can see this, right? All right, cool. Yeah, it's starting to even out. For those of you that it's just you, kudos to you. You're amazing. There are, we have records and information management specialists here at the archives that want to help you out. If you need more support from the chief administrative officer, you want some training for your staff, if it's just you and you're not quite sure how to manage it all by yourself, please reach out to us. We really want to help you out. And if you've got the amazing team, did anybody say D? Oh, yay, okay. If you've got, oh, that's in the other poll. Dang it, I was going to get really excited. Okay, that's okay. I didn't think anybody would say D, but that's the goal. To have the chief administrative officer is actually the chief administrative officer's job in the law to oversee the records management of your agency. And so next week, we have a training similar to this that I will be teaching for CAOs and attorneys. So if you would like to invite them to attend, I will do my best to tell them how important it is that they help you out. Okay. So we'll get into a little bit about why having some good records management it makes answering record requests simpler and easier to manage, especially if you get a lot of requests. So let's go over the timelines first. And if you remember 5, 10s, and 30s, that covers most things. So when you get a request, if it's an expedited request, then you need to answer within 5 business days. If it's not expedited, then 10. You might get people asking for an expedited request, but it doesn't actually need to be expedited. If it's something that is going to be for public distribution, I would expedite it. The law does say to answer the request as soon as reasonably possible, which might be less than 5 business days, but no later than 10 business days. So after you respond to the request, if you deny anything, you need to let them know, and they have the right to appeal to the chief administrative officer within 30 days of the date of the denial. And if you don't answer, then after that 10 days is met, that's the first day, and they'll go from there for 30 days, and that's their deadline to appeal. And then if the chief administrative officer receives an appeal, they have 5 or 10 business days, if it's expedited or not. Again, answer as soon as reasonably possible. And if that is denied, again, there's 30 days for the requester to appeal to the State Records Committee. If there's a local appeals board, which is a very specific type of body that's described and defined in GRAMA, not many people have one. So it usually goes straight to the State Records Committee. The local appeals board was intended for those good old days when we weren't meeting virtually and having people in St. George have to come to Salt Lake to meet the State Records Committee was a little unreasonable. And so local appeals board were a thing. And it's still in the law, but I don't know that the intent still applies, if that makes sense, because now you can join the State Records Committee meetings online for wherever you're at. And so the State Records Committee, if we receive an appeal, then if an appeal comes to me and I need to respond, either scheduling the appeal or denying the appeal with why. Usually it's because it's untimely. It hasn't gone to the chief administrative officer yet. That happens sometimes. And so I have to deny it or schedule it within 7 business days. And then it's scheduled for whenever. And then we got these new deadlines. The committee meets on the 3rd Thursday of every month. They do occasionally add extra meetings to kind of catch up on backlog. So they're meeting twice in June because we're scheduled out to September at the moment. So we're going to move everything up by having an extra meeting. So they meet regularly on the 3rd Thursday. And so 5 business days before that, is when a statement of facts is due to the State Records Committee, and I'll talk a little more about that later, but that's basically your agency saying what you want the committee to do. That's all it is. And 2 days before the meeting, so on Tuesday before the meeting, is the deadline for a petitioner to withdraw their appeal. And if you thought I send out an agenda a week early at the latest. And if you thought your appeal was withdrawn or it had already been resolved, let me know. I can reach out to the petitioner and remind them, if this is resolved, you need to let me know. And then on hearing day, both parties have 20 minutes to present. You don't have to take the whole time if you don't want to, but you get up to 20 minutes to present and 5 minutes for closing statements. And then the committee deliberates at the meeting. We get to sit and listen and know what the decision is before you leave. And then the committee has to draft the order, and that is sent out no later than 7 business days after the meeting. And then you or the petitioner have 30 days from the date of the order to appeal if you want to, or submit a notice of compliance if the committee grants the appeal, and so you have to provide records to the requester. You have 30 days to either appeal that to district court or send me a notice of compliance, which is really just an email saying we followed the committee's order and records were provided to the requester. That's it. So, let's see, any questions before I move forward? Which is really just me needing to stop for a drink. Oh, bad. All right, first tip. Statements of facts do not need to be treated like a legal brief. And attorneys are not the only ones who can present it to the committee. It's been an interesting trend. I've been attending the State Records Committee meetings for many years. And we used to have a lot more record officers presenting at the committee than we do now. Now it tends to be the attorneys, the legal counsel for the entity, which is absolutely fine. But don't feel like that's your only option. And if you feel comfortable, come to the State Records Committee as a record officer and presenting why the records were denied and maybe answering some questions that the committee members may have. That's absolutely fine. You can do that. If you'd rather have your attorney come, that's fine too. But the State Records Committee is an administrative hearing. So the statement of facts don't have to be treated like a legal brief. I don't know how stressed out attorneys may get in writing legal briefs. Maybe they don't mind it at all, but I wonder sometimes if it would be easier for attorneys if they knew that this isn't a legal brief. It's an administrative hearing. We just need to know what you want the committee to do, what you want the committee's decision to be, and why the records were denied, redacted, why the fee was denied. And it doesn't need to be that long. It's the committee's volunteering their time, right? They appreciate brevity. So anyway, I don't know if this helps with pressure or stress when it comes to writing the statement of facts that's due 5 business days before the hearing, but don't overthink it is all I'm really trying to say. And you can work with the government record ombudsman at any point during the request and appeal timeline. In fact, when you get a request, if you have questions, you can reach out to the government record ombudsman. You don't need to wait for it to be appealed. She's always there to answer questions, to help you out. And one benefit of engaging the ombudsman is that during mediation, there's a lot more flexibility on things that you can do to resolve the appeal. When you're at the State Records Committee, the committee can grant the appeal and say the records need to be provided. They can deny the appeal. But when you're in mediation, there are other things that maybe would satisfy the requester that are available to you that the committee cannot do. So I recommend reaching out to Rosemary Cundiff. I'll have her information at the end. And you can always work on resolving the appeal so you don't need to have the hearing at all. Okay, I'm gonna go into a couple more tips and tricks, and I'm talking a little fast, I think. That's okay. All right, so what do you want to know more about? Calculating fees, determining if the answer to the request is a record or not, maybe classification, dealing with partial denials, or is it something else? And let me know in the comments what you'd like to have some tips and tricks about. And again, there are some shapes at the bottom. You can click that, and then you can see the poll on the bottom right side. Let that sit for a minute and have another drink of water. A and B, okay. Oh yeah, with the poll, you can only pick one, huh? Sorry. A and B. Okay. All right. We'll go over A and B. All right, first of all, I want to cover a few things about the request, and then I'll talk about fees and classification. First of all, when you get a request, make sure everything is there. Do they have your name, the phone number? Is it a question, or are they asking for a record? If it's a question, it is not a GRAMA request. Kind of look at the GRAMA request like you're playing Jeopardy. They need to ask the question in the form of a record. Otherwise, it's just a question. You can treat it like you would any other questions coming in. It's just customer service questions at that point, right? Do you understand the request? This is when it comes to wondering if the request is reasonably specific or not. I would just ask yourself that. Do you understand what they're looking for? Did they ask for a fee waiver? If they did, you might want to look at how much the cost would be before you start gathering records. Has this already been provided? I know for some entities, you get there are some entities that when they get a request, they'll post the responsive records online. So if you get the request again, you can refer them to that, or requesters will ask for the same thing over and over. If the date span's different, it is a new request, even though the content is the same thing. That is a different request. But if it's something you've already provided, you don't need to answer the same request over and over again. And so when it comes to creating a record, gathering the records, you may, GRAMA says that you may compile, format, manipulate, package, summarize, tailor information, or provide the records in a format or program not currently maintained. We actually see that quite a bit at the State Records Committee, and I think it goes a long way when the committee sees that entities have done what they can to provide what the requester is looking for, even though it's not the exact form or format that they were originally requesting, but the content, the information that they want is there. That goes a long way with the committee. But you're not required to do that. You may do that. And GRAMA also says that you may not use the physical form of the record, the form the record is stored in, to deny or hinder, unreasonably hinder, it says, unreasonably hinder the rights of a person to inspect the record. One thing that the committee doesn't have a lot of patience for is when governmental entities come to the committee and say that the information is in a database and they can't get it. They do not have patience for that. And so you would have to, if you don't think you can actually get, there's no way to output the information from a system for the requester, I recommend when you come to the hearing, bring the administrator or IT professional as a witness to explain why it's practically impossible, to help the committee understand why it can't be provided. But something being in an electronic format is not reason enough to deny the record, which I think sounds obvious, but it happens at the committee quite a bit. And so not as much as it used to, but yeah. So be mindful that the physical form doesn't always matter. You can't use the form to unreasonably hinder the rights of the person, which makes it a bit subjective, right? Are you being reasonable or not? So if you have questions, again, I recommend reaching out to the Government Record Ombudsman and have your subject matter experts help you understand what can and can't be done when it comes to the systems your entity uses. If the records are online or in a public publication, you do not need to fulfill a request. Let them know where it is. You don't have to provide that record to them when they can already get it somewhere else. So bottom line, when it comes to getting that request, be as helpful as you can. It goes a long way with the committee and with the requesters to trust the entity that they're working with. So my tip is that when you get a request, respond to the requester. Let them know that you received the request, you're working on it, and so they know that they're not just being ignored. And this goes a long way with the committee as well. I do get appeals pretty regularly where the entity did not respond at all to the request or to the appeal to the chief administrative officer, which means I schedule it. That's all there's not even a question. It just gets scheduled. And sometimes they get resolved in mediation after that, but it always feels like we're starting off on the wrong foot because the petitioner is really frustrated because they haven't been heard. And so even if you end up not being able to respond within 10 days, I think it goes a long way with requesters and petitioners if you just respond and let them know that you received it. Okay, before you redact or segregate records, check if what is left is meaningful. If not, deny the request. So this is, when it comes to classification, you can have things that are normally public, and this is a later slide, isn't it? Yes, things that are normally public can have information that is public and is not public, which means you can segregate the records, you can redact some things, but when you look at the redacted record, if somebody that doesn't know the records like you do can't tell what it means, don't spend the time redacting, just deny the record, because it just leaves people really frustrated. We had an appeal, and I can't remember which appeal it was, but I guess it's happened more than once, so it doesn't matter. But we've had appeals where the requester received records, but it's just black lines. That's all it is. And it leaves petitioners really frustrated. It leaves the committee confused as to why the entity bothered to redact everything when there's nothing, no information for the requester to gain from it. They just paid for redactions and there's nothing there. So it's okay to deny the whole thing rather than providing black lines. And they can appeal that to the chief administrative officer and up to the state records committee if they want, and the committee can review whether or not the redactions were appropriate. And the committee understands that sometimes you can deny the whole thing because if you provided it with redactions, there's nothing left that means anything. So that's this tip. Before you spend the time or require the fees to redact stuff, just check if what is left is meaningful. So that's the normally public part of things in 301. And that is considered a partial denial. If you redact anything, when you provide the redacted records, you should also include the right to appeal to the chief administrative officer because it is a partial denial. They don't have everything, right? So that's that one. Private if properly classified is another odd phrase in 302. And this one, you have discretion. And you get a lot of discretion in answering these record requests because you have to look at the records and decide what the classification is, right? And I would recommend, I want to say don't overthink, but You do want to be careful that things that would be an unwarranted invasion of personal privacy are removed from the record. And that's the biggest thing for private records under 302 that comes to the State Records Committee, is an entity thought something would be an unwarranted invasion of personal privacy, which is really up to what you think, and that's your discretion. And so you can withhold information you think is an unwarranted invasion of personal privacy. If that gets appealed, that doesn't mean you did it wrong. And it's okay to be cautious. One nice thing about an appeal to the Chief Administrative Officer is that as the record officer, you can determine a lot of this record is private. I'm going to redact this personal information. Maybe you have a request for an investigation record. And so you're redacting witness statements and names, addresses, all that stuff, and then providing the rest of it that is really more summary information. And the requester hypothetically sees this and believes that too much has been redacted and appeals to the Chief Administrative Officer. The Chief Administrative Officer can look at what was withheld and remove some of the redactions, saying, we decided that you can have this page and this page, but we're still going to withhold these other things. The Chief Administrative Officer can do that. And so it is better as the record officer to be cautious and let the Chief Administrative Officer remove some of those classifications on appeal. That's okay. I recommend that you have a good dialogue going on with your counsel and with your Chief Administrative Officer as far as what to redact and what's questionable, what maybe you could or couldn't redact, and decide what you guys think. And then protected records under 305. The biggest one we see used is 305.17, which is for attorney-client privilege. And the other things can be really specific depending on the type of program it is and specific entity boards, records, and stuff like that. Those are all under protected records. If you're not familiar with the protected records, make sure you know go through and see which ones apply to your agency. Not all of them will. And keep a short list of what's under 305 that applies to you. And then that's my recommendation on dealing with the protected records under 305. Okay, so entities have a duty to designate and classify their own records. You don't have to have the same classifications as another entity. So this means that a lot of entities have very similar processes and similar records, but that doesn't mean they're exactly the same. You can have two police departments that have the same kind of template for an investigation file. And one department decided that they're going to keep witness statements with theirs and another department doesn't, which means they're going to have different classifications because one has more private information or private considerations than the other. Even though the process is kind of the same, but the way they manage the records is a little different. And the record series might be called the same thing. The description might be essentially the same thing. That doesn't mean you have to have the same classification. And so this actually happened with an appeal. All right, I'm going to skip ahead because I don't want to talk about this one. Okay. So this was a hearing that we had last week, Onysko versus the Attorney General's office. And he had received records from the Division of Risk Management. And they were attorney payroll records with a contracted attorney's office, I believe. And so there were essentially a couple columns, and Risk had redacted a middle column and some other things saying it was attorney-client privilege. And the Attorney General's office had redacted that middle column as well, but different things in addition to it. So the redactions between Risk and the Attorney General's office were not exactly the same, but they did overlap. That middle column was not provided by either of them. They both looked at the record and said, this is attorney-client privilege. And that's okay. It's okay that different offices kind of made different decisions. The use of the records is different, and it doesn't mean either of them did it wrong. But the overlap does emphasize that this is attorney-client privilege. And so the committee determined that the records were properly classified and the redactions were proper for the Attorney General's office. The requester, the Division of Risk Management, that part of the request was not appealed to the State Records Committee, but it was part of his presentation that he had received information from the same records from a different office. And so he thought that meant that the redactions were questionable. Anyway, I'm sorry. I hope that doesn't give anybody a headache. Okay, so tips and tricks to save you headaches later. This is all records management, okay? We want you to have a records and information management team that have some allies, some subject matter experts that you can talk to, that you can call. And a big thing is to be familiar with the records of your agency, because the more you know about the programs, the processes, the records of your agency, the easier it is to find out if there are responsive records when you get a request. And so you would want to have somebody from HR that is familiar with the kind of requests that you get. Just have an ally in each of these departments, right? An IT professional, this might be more than one person if you have multiple systems. And risk management, your attorney. Your attorney is your friend, and they can absolutely help you determine when you're wondering if a classification is correct, if something should be withheld or not. And when it comes to presenting before the committee, they could do it for you if you want, or they can help you prepare, and have as many subject matter experts as you can get. For every program, every function that your office has, hopefully you have a subject matter expert that you know. Even if you don't actually have a RIM team and it's just you and a couple other people, get to know the other people in your agency that deal with the different programs. And you end up kind of building the team by yourself, but it really helps when you're dealing with requests to know when you get a request, then you're familiar with what they're asking for one thing, but you also know what is involved in providing the records. Does that make sense? Okay. When you answer a record request, let the requester know how you conducted the search. This one might actually sound like a soapbox, because you don't have to. It is not required in GRAMA for you to tell them how you conducted the search, but it goes a long way with the committee, for one, and it helps build trust with the public when you can explain the effort that you went through to find something, especially when there are no records responsive to the request. If you can let them know, we did a search, we checked this system, we checked this system, we did this, and we can't find anything, that goes a long way, especially when the appeal comes to the State Records Committee. If there's no description about how the search was conducted, it's left to the chair to decide if they believe there should be records or not. And if the chair thinks that there could be records, then a hearing will probably be scheduled. But if you explain how you did the search, and it looks like a good faith effort was made to look for responsive records and provide them, then we can deny the appeal for a hearing, because we know there's nothing responsive to the request, and having a hearing won't help them find the records because the records don't exist. So there are a couple responses I've seen from agencies that explain how they did the search, and it's always impressive. You can reply and just say no responsive records have been found, and a lot of times requesters don't believe, requesters might not believe that, and so they'll appeal. But anyway, I'm being redundant, but it goes a long way to let them know that you did try to find responsive records. So fees, GRAMA says, a governmental entity may charge a reasonable fee to cover the governmental entity's actual cost, and that's an important word to the committee, the actual cost of providing the record. This fee shall be approved by the government entity's record officer, or executive officer, your CAO, or maybe it's your council, needs to have reviewed your fee schedule and approved it. We have a question. Should we be providing appeal information to requesters if we find no information or records responsive to the request? That is a very good question. Yes, I would. I would, because even though there are no responsive records, they may consider that a denial. One way it's been worded that I've seen that I thought worked well is to say something like, insofar as you believe this is a denial, you can appeal to our chief administrative officer. This is their contact information. And then the chief administrative officer may say the same thing. We stand by our decision that there are no responsive records. They can appeal again to the State Records Committee, and they may or may not have a hearing. Usually not if there are no responsive records. And if they still disagree, they can take it to district court if they want. And that, again, that doesn't mean that you did anything wrong if they appeal. It's just part of the public's right to appeal if they believe there should be records. And that's just the nature of GRAMA, right? But that's a really good question. Yeah, I have actually seen with some agencies, they put that appeal information at the bottom of all of their responses. And even if they provide records and nothing has actually been denied, they still would say, if you consider any of this response to be a denial, this is how to appeal, which I think is a great service so that the public knows how the process works. Okay. So on fees, the actual cost includes staff time to compile, format. This is part of that you may, right? You may compile, format, compile. I put that in there twice, sorry. Manipulate, package, summarize, tailor information. That's not something you're required to do. You may do that, and you can charge a fee for that. And then the actual time, actual cost for the search, retrieval, administrative costs, and providing electronic services and products together. So sometimes if you can provide the record, but it's going to require hiring an outside IT professional because you're a really small office and you don't have that kind of expertise. If we can do this for you, but we're going to have to hire somebody to get it, and you're going to have to pay for that. So when it comes to determining the actual cost, I highly recommend that before you even get the request, know what is involved in providing access to different things. What is the turnaround time for having some kind of output from your IT professional from a certain system? Maybe one system's really temperamental and there's really only one person that knows how to get information out of it, then that'd be good to know, right? And GRAMA does say that the fee needs to be the cost of the wages of the lowest paid person capable of doing the work. There we go. I'm having a hard time talking. There we go. So even if you have somebody who is at the top of the pay scale doing the work, but it could be done by somebody else, but they're not in the office, the somebody else that is paid less an hour is what you go off for the GRAMA fees, because we want the public to be able to access records, and fees should not be used to hinder access. They're just the actual cost of providing the record. So if you have a fee schedule, if you don't have one, it's worth the work to do it. There are some offices that have a fee schedule posted on their website. They have maybe a GRAMA page. If you want records, this is how much things cost. If you want copies, if you want something from this system, it's going to require this much time per case file or something. And there's also another, I've seen one entity, I think it's the state auditor's office, that has, the GRAMA form has the fee schedule on it. So when you make a request, you already know what the cost might be, which I think is awesome. I think that's great. So that it provides transparency so that the public is not surprised when they're charged a fee, right? On the Open Records portal, they can put in an amount to let me know if it's going to cost more than this. That doesn't mean they're willing to pay up to that. Maybe usually they are, but maybe they're going to appeal either way. But they want to know how much it's going to be, especially if it's over that. If it's under that, then it's fine. Sorry. So when you're making your records management policy, have GRAMA and access and your fee schedule part of your policy. And this takes care of a lot of confusion. We get quite a few, most fee waiver appeals that come to the State Records Committee have a question about who is the lowest paid person capable of doing the work. Does that include the benefits per hour? The committee asks about that sometimes. And anything that can remove the confusion about how the cost is calculated really helps. And never, ever use fees as a deterrent for access or a denial. I know this sounds obvious, but if there is a fee charged that is exorbitant and you don't think they would ever pay it, if they do, then what, right? Make sure that whatever the fee is charged, you're still going to be able to do the work for that fee. There was a appeal that came to the State Records Committee recently, Jennifer Orton versus Salt Lake County, and the fee was over $10,000 initially. And in my experience, I haven't usually seen petitioners pay that, but they did. And I got the impression that the respondent just kind of felt like, oh my goodness, we're going to have to do this now. And I'm not saying that they use the fee as a deterrent, but never do that. Sometimes the fee is expensive and it is what it is, but never use the cost as a deterrent or as a denial. You can deny a fee waiver, you can deny access to the record, but don't use a fee as a deterrent. And anytime anything is withheld for any reason, make sure you let them know they have a right to appeal to the Chief Administrative Officer and have that as part of your response. And then they can appeal if they want to, but they might not. These are your allies here at the archives. If you have records management questions, if you want help in getting buy-in and creating a records and information management team, depending on the type of agency that you're with, changes who your person is. And so when it comes to state agencies, especially, go to our website and you can find out who your room specialist is. All right, we've got about 15 minutes left to go over some cases, unless there are any questions. Okay. Again, an appeal does not mean you did anything wrong, okay? I actually enjoy, of course I do, but I enjoy listening to the hearings at the State Records Committee. We've been impressed with a lot of respondents and entities and how they have worked to provide records and be transparent and to help requesters out. We've got a lot of superstars coming to the State Records Committee. So I already talked about this one, Rosenstein versus UDOT. So the request was for all records related to T Group, which was a contractor that UDOT had. And the request was voluminous, but voluminous does not always mean it's not reasonably specific. That can be debatable, but you definitely want to look at that if it's a voluminous request. But if you understand what they're asking for this request, it was a lot of records. And so they came to the State Records Committee and the volume was intense. And so the committee continued the appeal several times and told the parties to work with the ombudsman to work through all the responsive records and to come back and just get it down to what was not public that the committee actually needed to look at and determine if it was public or not. And so it went on for a few months, and by the end of it, the committee went in camera and looked at the records that were left over that were classified non-public because they were drafts, attorney-client privilege. There were a couple of different things. And by the end of it, what was withheld was properly classified, and they had worked a lot with the ombudsman and meeting outside the committee to resolve the request as much as they could. But they came to the State Records Committee every month for a couple months and gave this little 5-minute summary. So if there are a lot of records, the committee's not going to go over everything for you. They'll go over what is withheld and determine if it is been properly classified or not, but they're not going to answer the request for you, right? And so, not that UDOT didn't answer the request, but it was just, there was so much to do and go through that the committee just said, you guys work on that and come back when everything's been narrowed down. O'Neill Chambers versus Orem City. So this was a request for a copy of a police report related to an incident where Mr. Chambers was the victim of an alleged assault. And so the request, the initial request had denied several things. And when he appealed to the chief administrative officer, more records were provided. And so we went back and looked at this and decided we can give you these other things that were withheld, but we still can't provide a couple other records that had witness statements and a few investigation things. And so that came to the State Records Committee, and the committee agreed with Orem City that the records would constitute an unwarranted invasion of personal privacy. And the records were created by Alpine School District for an investigation that they had, but Orem City also did an investigation, and so Alpine had given a copy of the records to Orem. It wasn't a shared record agreement. They were just these separate investigation files. And so Orem City had to review the records and classify the records. So there was a question for a little while there if the records were Alpine's or Orem's. Oh, okay. The State Records Committee is an administrative hearing, not a court. So when it comes to your statement of facts, especially, we're not a court, and sometimes people will object at the State Records Committee, which I find a little amusing because we're not a court, and so it just sounds weird to me. But the committee is made of volunteers and that do their best. They review the case files, they study GRAMA, and they do their best. And so this one, Tiffany Gilman versus Unified Police. This one was really interesting. Ms. Gilman is writing a book about Nancy Wilcox and Ted Bundy. And so there's a missing person case report for Nancy Wilcox. She went missing 45 years ago. And Ted Bundy had admitted to killing her, but her body has never been found. And so the records were denied because it's an unsolved case, and so the investigation is considered open. And so the committee reviewed the case file in camera and determined that it was not actively being worked on to the point that they felt like it couldn't records could not be disclosed, but they did grant the appeal with redactions. There was still a bit that the committee agreed should not be public yet. And yeah, it was interesting at the end of it. Marie Cornwall, she's a citizen representative on the committee. She's a sociologist by trade. And Dr. Cornwall had asked Ms. Gilman at the end to do right by Nancy and to make sure that, as she wrote her book, that she still respected the privacy of the people she was writing about. It was a really interesting case. And you can listen to the case files, listen to the hearings on the Public Notice website. And the order number is on the slide. You can view those on our website as well. And this is a picture of the current committee. The other picture is years old. We have the director of the state archivist is on the committee, 2 citizen members, and one is Marie Cornwall, the other one is Nova Dubovic. A media representative, who is Tom Haroldson right now, he's from Davis County. A political subdivision representative, and she's appointed by the League of Cities and Towns, I think. And that's Nancy Dean, she's from Clearfield. And then a private sector records manager, Mark Buchanan. And then we have an electric records, a person with records, let me try that again. A person with electronic records experience. There we go. And that's Ed Beeler. He's the police chief in Bountiful. And it's been really nice having his perspective on the committee because we get a lot of law enforcement hearings. And so he's really familiar with what is possible in redaction of body cam footage and audio and stuff. It's been really nice having him there. Speaking of which, so this is Sam Stecklow versus West Jordan Police. There were several appeals requests from Sam Stecklow. He works for, he was doing a story for the Tribune and Frontline about Garrity statements and officer-involved critical incidents. And some entities provided Garrity statements, others did not. And one that was appealed was West Jordan and Cottonwood Heights. And Garrity statements at the time of the hearing were not specified in GRAMA. There was a bill last legislative session that added something to GRAMA because of this hearing, I believe. And so the committee determined that there is a significant public interest in these records and said a few times in the hearing that this probably should go to court, and it did. The records, the committee determined that the records should be public. The records were properly classified, okay? The entity classified the records. No, that wasn't in this case, but that does happen. That the records are properly classified, but there's enough public interest that the records should be made public. For this one, the committee determined that the records should have been classified as public and granted the appeal. And so this is in district court right now. So we'll see what happens with this one. Okay. This is Rosemary Cundiff's phone number and email. And mine, if you've got GRAMA questions, if you've got questions about an appeal, you absolutely can call or email either of us. We are here to help you out. And we're going to leave the rest of the time open. If anybody's got questions, if you've got a tricky situation that we'd just like to pitch to the group and we can talk, that's the rest of the time is yours. So thank you for coming, everybody.